Honorable Senators, we're ready to begin. Today, the Standing Senate Committee of Foreign Affairs and International Trade is continuing its examination of the subject matter of those elements contained in Divisions 4 and 16 of Part 3 of Bill C-4, a second act to implement certain provisions of the budget tabled in Parliament on March 21st, 2013, and other measures. This morning, we will hear from a panel that will address Division 16, which amends the Immigration and Refugee Protection Act. We welcome to our committee, on behalf of the Canadian Bar Association, Ms. Tamara Thompson, Director, Legislation and Law Reform, and Mr. Mario Bellissimo, Chair of the Immigration Law Section. They are before us here in the Senate. We'll turn to Ms. Thompson to start. Welcome.
Thank you, Madam Chair and Honourable Senators. We're pleased to appear before you today on behalf of the Immigration Law Section of the Canadian Bar Association on Division 16, Part 3 of the BRIC, otherwise known as Bill C-4. The Canadian Bar Association is a national association representing over 37,000 members across Canada, and part of our mandate is to help in the improvement of the law and the administration of justice. It's in that rubric that we have examined the part of the bill that you are looking at today. The members of the Immigration Law Section comprise lawyers whose practices embrace all aspects of immigration and refugee law in Canada. You have received the letter that we prepared on the division, and I will ask Mr. Bellissimo to address the concerns that we've raised.
Good morning to you, Madam Chair, Honourable Senators. The changes in immigration law have been fast and furious. There's an old saying, in the face of winds of change, the pessimist complains about the wind, the optimist expects it to change, and the realist adjusts the sails. To this end, we will optimistically suggest adjustments. There's no doubt the EOI system is a game changer and carries with it very exciting possibilities. Efforts to modernize, adapt, and adjust the selection system for economic class immigrants are important, and the CBA section commends the government for doing so in a proactive way. However, the CBA has steadfastly objected to omnibus legislation like Bill C-4. Enacting important changes in diverse and unrelated acts in areas in a single bill limits meaningful comment and debate. The issue is compounded in immigration law because of a growing reliance on ministerial instructions at the expense of parliamentary oversight. Here, there will be no mechanism to reconsider the EOI system once the amendments are made, because key decision-making will be undertaken by ministerial instruction. Ministerial instruction cannot be reviewed by Parliament and is not subject to judicial review. The powers vested in the minister are significant. To highlight a few points, and I will try to move through these fairly quickly, Section 10.31 affords the minister 12 additional powers, including the authority to define classes and criteria eligible for participation. 10.3 sub 5, the minister can, by instruction, provide for criteria that is more stringent than current criteria or requirements under any other division in the Act. This is extremely broad language. Section 10.4 allows the minister to disclose private information on undefined entity. We heard yesterday from senior government officials that those entities might in fact be the provinces and the territories. If so, it should specifically state it in the legislation. Section 91.5 allows the minister to designate a body, the authority to represent or advise a person for consideration in connection with submissions of an EOI. So the details are critical. We set out 10 questions in our submission that seek clarification on a myriad of issues, including eligibility, consultation periods, who these various entities are, what, if any, fees will be imposed in carrying out the EOI system. Further still, the automated system which will, our understanding, will undertake the eligibility assessment has yet to be developed, and the costing model are still being developed. The costs of the system are not before a committee studying a budget bill. For these reasons, sufficient time to study these amendments should be extended to stakeholders, including subject matter experts such as the Canadian Bar Association, that share in the interest in the successful implementation of immigration delivery and processing. Other measures could be considered in the interim, such as a pilot project, for example, launched for a select number of applicants in a specific category. This would allow for the collection of empirical data, and then we could be in a stronger position to conduct meaningful assessments. Senators, predictability and transparency are critical. Immigration applicants are as worried about the certainty of selection as they are about long processing times and employment opportunities. Although we understand the need for flexibility, timeliness, and proactivity, predictability of the system is fundamental to attracting the best applicants, and it does not have to be an either-or scenario. The changes to the Canadian Experience class with overnight introductions of caps in ineligible occupations is a recent example of ministerial instructions exercised without notice to the detriment of certain applicants. People plan their lives around the possibility of immigrating to Canada. They commit to working or studying in Canada, subject to meeting certain selection criteria. Selection criteria can be responsive to labor market needs without being a moving target. Given the importance of this legislation, and given that a just-in-time immigration system is in everyone's best interest, it is unclear why we are moving forward with this legislation when the program is unclear as to several details. Leaving incredible scope and implementation to ministerial instructions opens this initiative, regardless of political party, to serious criticisms and concerns regarding transparency, lack of parliamentary oversight, and potential politicalization of the program. The CBA section therefore makes two key general recommendations. It recommends that the passage of these significant legislative amendments be delayed and additional time be set out for consultation and examination with stakeholders, including subject matter experts like the CBA, on the impact of potential legal issues as we have more detail and more substance. Two, that insofar as the amendments proceed with ministerial instructions, the legislation reflects that ministerial instructions will be submitted for parliamentary scrutiny and public debate before they are implemented. The Minister of Citizenship and Immigration Canada, in testifying before the House of Commons Committee, also indicated this is a drastic change, an important change, and it is an exciting change. And from the CBA's perspective, it would be unfortunate if it was undermined because we're moving forward in this factual vacuum. I thank you for your time and consideration.